I'm Shaye Larkin and thank you for visiting. If you've watched my other videos, you know that I'm a bankruptcy attorney here in San Francisco, and for more than 20 years now I've been preparing Chapter 7 and Chapter 13 bankruptcy cases for my clients. In this video, I'm going to explain preferences, and I recommend you watch my video about the bankruptcy trustee and their role before watching this video so you have a good idea of who the trustee is. But for the sake of being concise, I will say if you're going to file a Chapter 7 or a Chapter 13 bankruptcy, there will be a trustee appointed, and their job is to administer the bankruptcy case. Now, one of the Chapter 7 trustees' many duties is to recover preferential payments to creditors. And there are different rules for different types of creditors, and there are different rules for different types of debtors. Let's talk about the different types of creditors first. There are basically two types. There are insiders and there are regular creditors. An insider is a creditor who has a special relationship with the debtor such that they have reason to know about the debtor's particular financial situation, and it's because of this close relationship that there are special rules that apply to them. A family member like your mom or your business partner, they have a special relationship with you, so they are subject to the insider rules. They're insiders. Everyone who is not an insider is a regular creditor. Now, both types of creditors have different categories. There are secured creditors like your mortgage lender and your car lender. They have a lien on property that you own, so they're secured. There are priority creditors, and there are many types of priority creditors, but one example would be the IRS. If you happen to owe tax debt for the past 3 years, that would be a priority tax debt, and in that situation, the IRS would be a priority creditor. Then there are general unsecured creditors. A creditor who is not a secured creditor or a priority creditor is a general unsecured creditor. And the significance of these categories is that in a bankruptcy case, if the trustee is going to be recovering assets for the benefit of creditors, secured creditors get paid first, priority creditors get paid after that, and if there's anything left over, it goes to the general unsecured creditors. That's who the trustee is going to be concerned with when it comes to preferential payments to creditors. General unsecured creditors. The trustee wants to make sure the playing field is level for all creditors, but particularly general unsecured creditors. So that's who we're going to be talking about today in this video. And preferential payment to creditors is very simple. It means that a payment was made to a creditor that results in that creditor receiving more money than they should have as compared to other creditors. So let's go over the rules. Now, if you're a consumer debtor and that means your debts are primarily consumer debts incurred for household purposes or living expenses, then you've made payments totaling $600 or more to a single creditor on an antecedent debt, that means a prior existing debt, within the 90 days before filing bankruptcy, outside the ordinary course of business, then those payments are presumptively a preference recoverable by the trustee. And that means the trustee can actually sue the creditor to get the money back in order to share the money with all the other creditors and make the playing field level. Now let's go over that a little more slowly because it's complicated. Payments must add up to $600 or more. That means total payments to a single creditor altogether adding up to $600 or more within the 90 days before filing bankruptcy. Now that 90-day term it's because you're deemed to be insolvent within the 90 days before filing bankruptcy. And if you happen to not be insolvent within that period of time, then of course these payments would be outside the preference rules. Ordinary course of business. That means basically bigger than usual. So say for example, you have an American Express credit card, and over the past year you've been making payments religiously on that credit card. You just pay your minimum monthly payment, and that's the amount you pay each month. And towards the end of the year you lose your job and you realize you're going to be filing bankruptcy. You stop paying your other creditors, but you want to keep American Express happy, and you're actually hoping that if you pay off that credit card, you won't have to list it in your bankruptcy and you'll be able to use it after bankruptcy. So you pay American Express $1,000 and pay off the card within the 3 months before filing bankruptcy. So that payment would be outside the ordinary course of business because it's bigger than what you normally would be paying. And because you haven't been paying your other creditors, it's a preference. You're preferring American Express over your other creditors. And to the extent that your payments total $600 or more within the 90 days before filing bankruptcy, that's money the trustee could recover. And as a practical matter, paying off a credit card right before filing bankruptcy doesn't make good financial sense because the creditor is going to find out about your bankruptcy anyways, one of two ways. Either they pay into the bankruptcy notification system to find out when their account holders have filed bankruptcy, or they check your credit regularly and they'll find out, and once they do, they're going to close the account and you won't be able to use that credit card anymore. So that doesn't make good financial sense. But other than that, paying American Express that extra money doesn't really affect you in your bankruptcy case. It's a bummer for the creditor, but you're still going to get your discharge if you're otherwise entitled to receive a discharge, irrespective of any preferential payments that you made. So those are the rules with regard to consumer debtors. Let's talk about non-consumer debtors. A non-consumer debtor is someone whose debts are primarily non-consumer debts, like business debts or tax debt, and the threshold is much higher in that situation before the trustee can recover the money. The payments made within 90 days before filing bankruptcy must be equal to or greater than $6,825. And of course, they must be on an antecedent debt, that means a pre-existing debt, and outside the ordinary course of business before the trustee can recover. So in that situation, it's a lot harder for the trustee to get that money back. I have a lot of non-consumer clients, and I very rarely see payments equal to or greater than that amount in the 90 days before filing bankruptcy. That's a high amount, and it's a much higher threshold. So those are the rules with regards to regular creditors. Let's talk about insiders now. Mom and dad. The rule for them is much stricter. The trustee can actually go back a full year, 12 months, to recover preferential payments, and they could be payments totaling any amount. They don't have to add up to $600 or more. But as a practical matter, if the payments add up to only a small amount, the trustee is probably not going to waste their time because it has to be significant enough to make a difference to the other creditors and to the trustee. They collect fees when they recover preferences to make it worth their while. So say it's a big amount that you have repaid your mom and dad in the past year. Are there any defenses? Yes, there are. One I've already mentioned, payments made in the ordinary course of business. Say, for example, that last year you borrowed $20,000 from your mom and you made an agreement promising to repay your mom $400 a month, and you've been doing that each month for the past year, for the past 12 months. Those payments are within the ordinary scope of business. So most likely the trustee is not even going to try to recover them because of that defense. It's a strong defense. But what if you repaid your mom in chunks? You borrowed $20,000 from your mom last year, and this January you sold your car and you gave your mom $10,000, and then in April you got your tax refund and you gave your mom $3,000 more. So those are lump sum payments. They're outside of the ordinary course of business unless all of your creditors receive $10,000 in January and $3,000 in April. In that situation, then you can argue ordinary course of business. There's another defense, which is contemporaneous exchange for new value. Say you borrowed $5,000 from your mom a few months ago and you need $3,000 more, and your mom says, I'll give you $3,000, but you have to repay me that $5,000 first. So you repay the $5,000 in contemporaneous exchange for the new $3,000. That's outside the preference rules, and that would be an exception and a defense that can be raised if the trustee decides to go after your parents. All right, say these exceptions don't apply. You've made these big lump sum payments to your folks. What are you going to do? It would have been best if you would have talked to a bankruptcy attorney before making these payments, but hindsight is 2020. There are still things you can do to ameliorate the situation. And the first thing that you can do is wait to file bankruptcy. Postpone filing your bankruptcy until it has been at least 12 months since you made those preferential payments. Say, using the previous example, you paid your mom $10,000 in January when you sold your car, and then $3,000 in April when you got your tax refund. Well, if you wait until next January to file bankruptcy, that $10,000 payment would be outside the scope, and the trustee can't recover it. But the trustee can still recover the $3,000 payment. So it would be better to wait until next April to file bankruptcy. If that $3,000 payment was only $300, then I would say go ahead and file, because the trustee is probably not going to try to recover that $300 payment. Now, maybe your situation is such that you cannot wait to file bankruptcy. Your wages are being garnished, or your house is about to be foreclosed, or your car is about to be repossessed. You cannot wait. Is there anything else you can do? Yes, there is. Possibly you could file a Chapter 13 bankruptcy. The Chapter 13 trustee is not going to go after mom and dad for the preferential payments that you made, so long as you pay a sufficient amount into the plan that would result in your creditors receiving the same amount they would receive in a Chapter 7 bankruptcy if the Chapter 7 trustee recovered that money from your parents. So by filing a Chapter 13 and paying the required amount into the Chapter 13 plan, you're basically leveling the playing field, and the Chapter 13 trustee is not going to go after mom and dad in that situation. Of course, there are certain eligibility criteria that must be met in order to file a Chapter 13, and you may ultimately need to be paying more into the plan than just the preference amount, because Chapter 13 is a whole different ballgame. But that's one other option if you cannot wait to file bankruptcy. Now, maybe Chapter 13 is not an option for you because maybe you lost your job 3 months ago, and one of the requirements of filing a Chapter 13 is that you have regular income. Is there anything else you can do? Yes, there is. You can negotiate with the Chapter 7 trustee. You can say to the trustee, look, I know that I've made preferential payments to my mom and dad. I don't want you going after them. I don't even want them knowing about my bankruptcy because they're going to be really upset with me. Can I pay you the preferential amount? And most trustees, I think, would be inclined to accept that offer. You don't even have to offer to repay the full amount. You could say, like, for example, if the preference amount is $3,000, you could say, look, I just lost my job. I don't have a lot of money. Will you accept $1,500? And maybe the trustee might accept. It's certainly worth a try. You can also ask if you can make the payment, if you can pay it back in payments over time. As long as the trustee believes it's a reasonable offer, I think they might accept. I think some trustees actually have a heart and would rather get the money directly from you than go after grandma for the money that you repaid them. So that's another possible solution. Now, I want to mention also that it doesn't help to, instead of paying back mom and dad directly, to repay their creditor, and I'll give you an example of that. Last year you fell on hard times, so your mom took out a home equity loan and gave you $30,000. Then you were able to finally sell your stock, and you sold your car, and you gave your mom $30,000, but instead of giving it directly to your mom, you gave it to the home equity loan lender, Bank of America. Does that resolve the situation? No, it doesn't, because in that situation, the trustee can actually sue both your mom and Bank of America. All they care about is whoever pays the money first. So it didn't resolve the situation. I wanted to make sure I told you that. So that's preferences. Yes, it's complicated. It's not a sexy topic, I know, but it's very important that you understand it. And bankruptcy is a really complicated process. Even if you have a simple case, it's really best to have an attorney. In my videos, I just mention some of the issues that can come up. I'm not mentioning everything. You should get an attorney if you want to file bankruptcy, just to make sure you have peace of mind and things go smoothly. Watch my other videos. Thank you for visiting, and have a great day.